Chairman, members, thanks for having me. My name is Jeremy Newman. I'm Vice President of Family Freedom Project. And, for those of you who've been around for a while, you've probably seen bills on this topic come up quite a few times. Chairman Dutton, you've probably seen it more than anybody else. And maybe the most significant thing about this particular bill is that everybody is for it. And if you've been around for a while, you know that has not been the case in past legislative sessions. And the reason it's the case this time is because all of the stakeholders worked really, really, really hard to figure out how to craft language that everybody could support so that we could put the issue to bed and get some clarity on this issue. And the state of the law on this is nobody disputes that the parental presumption exists. The confusion comes around how do you apply it in certain specific types of situations, and that's what this bill is giving clarity on. And just for some context for you guys, we did a review of the 20 years of appellate cases in Texas post-Troxel in 2000 to try and figure out how often are the appellate courts overturning lower courts for getting this wrong, the parental presumption wrong. And what we found was that in almost 50% of the appeals, they were overturning the lower courts for misunderstanding how the presumption applies. And in a mandamus, which is basically an appeal of a temporary order, it was almost 80% of the time. And the thing that this bill resolves, hopefully, is a tremendous amount of confusion that those numbers illustrate. And I think the additional thing that it does is by reducing the confusion and by reducing the litigation, certainly the unnecessary litigation on the question, it helps reduce the weight, the burden on the family and the children. This is one of the points that Troxel made, is that the existence of the litigation itself is a burden on the family and a burden on the child. And the affidavit requirement in particular that has been mentioned before helps sort of the wheat from the chaff at the very beginning to say, if you're not at least alleging facts sufficient to overcome the presumption, then you can't even get in the door at the beginning. So we're strongly in favor of the bill. We've worked on this in some form or fashion for about 10 years, as have several other people here, and we strongly urge your favorable consideration.